Hi, everybody. This is Justin McGill. Today, I want to talk about three definitions that I think are very key to our understanding of how the founders set up our system of government. So, we've talked in the past about our government being set up under a rule of law organization. So, we have a constitution that was established. It's not absolutely permanent because it can be changed, but it is very difficult to change it. So it's a fairly permanent, uh, established standard for how our government should operate. And then all of our laws are supposed to comply with that. And then all of our courts are supposed to comply with the Constitution and with the laws. So if we follow that, we have rule of law. Everybody is held to the same standard all the time. So the three terms that I want to discuss today are constitutional, lawful, and legal. And these get conflated a lot, they get tossed around a lot. So I want to define them, distinguish them, so that I think it'll help everybody understand a little bit better why our founders set things up the way they did. So what does it mean if something is constitutional? Constitutional means it complies with the Constitution. It doesn't violate the Constitution. It doesn't go against the Constitution, but it goes along with what the Constitution says. So something that is lawful goes along with the laws created by legislature, created sometimes by the court through what's common law. Anymore, we don't have much in the way of common law. So when we talk lawful in this video, we're going to be talking mostly about legislation. And then the last term is legal. So what's legal is what complies with what the court says. So these three get thrown around a lot. They get conflated. So we want to try and separate out some of the differences. So if you have a law that is passed that is in violation of the Constitution, it is not constitutional. It is still a law on the books, but it is not constitutional. Now, if the court says that this law is okay, in the sense that they don't disqualify the actions under this law, then that law is both lawful and the actions under it are legal, in spite of the fact that both of them are unconstitutional. You can also have a law in compliance with the Constitution, so it is lawful and constitutional to do a certain thing, and then the court can say that it is illegal. So these three terms don't necessarily reflect each other. Now we know if we're going to have rule of law, you cannot have laws made in violation of the Constitution. They would be naturally void if that were to happen. However, how we get to that point of pushing back on those unconstitutional laws, that's a discussion we're going to have another time. The same with the court system. You can't have rule of law if you have lawless judges. So if they're not complying with the laws, you can't have rule of law. You have judges as rulers at that point. So we see that distinguished for the court system in the Constitution, starting off at the very beginning. Article 1, Section 1, Clause 1. All legislative powers herein granted shall be vested in a Congress of the United States. So this is a very unambiguous, mandatory clause here. The courts have no legislative power. The executive has no legislative power. The only one that has any authority over legislation is Congress. That's the authority to create legislation, the authority to change legislation, and the authority to void or terminate legislation. It all rests with the Congress. Now, the president has a veto over bills, but once they are passed into legislation, whether by presidential signature or overriding his veto, he no longer has any authority to veto them. They are legislation. He can't change them. It is what it is. And it's the same with the courts. The courts don't have authority to void legislation. They don't have the authority to change legislation. Uh, and that's a common belief today, that the courts are somehow superior to legislation. It's not only against what the Constitution says here, and some people argue that Article 3 of the Constitution implies they have that power. So first off, the problem with that is it's intellectually dishonest to say that the court or that the Constitution very specifically states that the court does not have any power over legislation in the first article, and then in the third article to imply that they do have that. Very contradictory. Wouldn't work for a constitution. But we also have the Federalist Papers in Federalist 81, written by Alexander Hamilton. Alexander Hamilton states that he's in support of courts having authority over legislation, and yet even in spite of his support of it, he states that the Constitution, not one single syllable, gives the courts that authority over legislation. So we have not only it's stating it in the Constitution that the courts don't have that authority, we see Alexander Hamilton stating that even though he wishes the courts have that power, that not one single syllable of the Constitution gives courts that power. And then we also have, again, that common sense of you can't have rule of law if you have lawless judges. And we'll get into more on the courts in another video. We'll do one specifically about courts and how they were intended to run and the protections they were intended to create. So we have these three different terms, and we need to understand what effect they can have on our government. So if you have a executive that is acting unconstitutionally or unlawfully, you can go to a court and get an injunction against them. An injunction is simply the court telling the executive, you have to stop what you're doing right now. So court actions are very limited in their scope and their authority. They're very limited in their time period. So a court can say, you have to stop right now, and then it gets appealed to the next court, and the next court says, no, you don't have to stop at all. So the security of having a good court order may not be very secure. And it's not necessarily intended to be a permanent solution. It's intended to be a short-term protection. So then you have the laws of your state or of the United States. They're intended to be a little more permanent. They're intended to be a little more long-lasting. So the Congress is given the authority to put together these laws in compliance with the Constitution. In order to change those laws, we would then have to influence Congress. And this is one I think people really need to think about. Influencing Congress requires a little bit more of a targeted action. Your specific representative needs to hear from you. So if I represent Alaska and somebody from Florida is calling me on the phone telling me what they think I need to do, I'm probably not going to listen to them. It probably doesn't matter to me what they think I need to do. We'll get into that a little bit more in another discussion too. I want to break down legislature, and also some of the local municipalities ordinances and how those all play together. But I want people to think targeted. So you have the courts for a short-term, immediate need. You have the legislature for more long-term solutions. And then you have the Constitution. It's intended to be a very permanent document, can be changed if needed, but it's a very difficult process. They don't want it changed willy-nilly when the founders were writing the Constitution, so they made it difficult to make those changes. So if you're going to take a little bit of time and research some of this and think about it, I definitely encourage you to read some of the founders' writings on these things, not only on rule of law, which I always encourage that as a basis for thinking about government, um, but also some of their writings in how they formed the Constitution and their discussions on whether or not the Constitution should be accepted in the form that it stood in, um, and also how they acted with the courts and with the various Congresses. So, for example, Pennsylvania, one of their first constitutions, created a council of censors. This group was chosen and met once every 7 years. Their sole purpose was to find acts of Congress or acts of the court or acts of the executive that were in violation of the Constitution. They were able to research through the last 7 years or more of acts and actions and decide which things were constitutional and which weren't. However, they weren't allowed to make any changes. That authority still remained with the Congress. It was still always the Congress's job to decide what was constitutional. And we see that in the founders' writings when it comes to the U.S. Constitution. When the question comes up, who gets to decide what's constitutional, there's three layers. So the first layer is the Congress themselves. So the U.S. Congress themselves or the state Congress itself, they get to decide what they believe is constitutional while they're creating legislation. The second check is the states for the U.S. Constitution, or for the state constitutions, the local municipalities. If they feel that what the Congress has done is in violation of the Constitution, they can push back. So when it comes to the states, they're sovereign states. They're not subservient to the U.S. government, except in very limited and specific areas. So if the U.S. government, the U.S. Congress, creates legislation that steps outside of those boundaries, the states can choose to ignore it, to nullify it, it's called. And we see the founders doing this very early on with the Alien and Sedition Acts. We see it coming out of Kentucky and out of Virginia, the rights of states to nullify unconstitutional actions of Congress and of the president. In states, it's a little more tricky because the municipalities are not sovereigns. They are corporations under the state's rule. So there's a little bit of difficulty there in that sense. However, it is still the responsibility of every government at every level to push back against unconstitutional actions. It's their job to stand up for our natural rights, even against our own leaders at times. And then the last dimension of determining constitutionality rests with the people. So in the U.S. government, we have our House of Representatives that represents the people, and we have the Senate, which originally represented the states. So the states had a direct influence on the Congress, and the people had a direct influence on the Congress. After things passed out of the Congress, the people were protected by their states against any violations of the constitutionally protected inherent rights of the people. And then at the lowest level, the people themselves have the right to determine what things have been done that are constitutional or unconstitutional, and they get to push back there. Now, originally, the people had militias that they were able to use to add some authority to their pushback. We've since surrendered our rights to militias, so we don't have that anymore. But we still do have local municipality governments. We still have organizations that can provide some force when pushing back. But we, the people, are the final arbiters of what is constitutional and what is not constitutional. And we need to take that up, and we need to put the pressure where it belongs, whether it's with our state governments, whether it's with our U.S. Congress. We need to be making that appropriate appeal to those authorities who have the power to put things right. So just something for you to think about today. We've got some more videos specifically on the three different branches of the government and their creation and how they're supposed to function. But for now, just think about the common sense of the patriots. Do a little bit of studying on their writings, and we'll hopefully you'll have a new video from me soon. All right, thank you.